Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good afternoon, Council. Welcome to the 4th Court of Appeals. I'll wait for Mr. Redden to. Good afternoon.
Good afternoon, Your Honor.
Good afternoon. Good afternoon, Council. Welcome to the 4th Court of Appeals. Today we are in a virtual world and presiding over oral arguments via Zoom. Our YouTube channel is streaming live, and we all wish we can be together in the courtroom, but this is unprecedented times, so we are all mindful that we're doing the best we can. First and foremost, we are excited to be finally here with you. We know that we appreciate your patience. We know that there was a long time in preparation for the record, and also the pandemic, and to boot, there was a ransomware attack on our network statewide. So thank you for your patience. We are glad to be with you here today. Today we are here on Southcross Energy versus Gonzalez et al. Number 04-18-00515 CV. And before I ask for announcements, I want to reassure Council that we are approaching this with a great amount of patience and flexibility. In the event one of us gets disconnected, we will pause, and our Clerk of Court, Michael Cruz, will do his very best to reconnect us. With that, we will also allot time in the manner in which it was listed in the order that was issued yesterday. In the event that you ask for us to consider going outside of what is listed in the order that was issued yesterday, please let us know. And Council, we are ready for announcements.
Good afternoon. Marie Jameson on behalf of Southcross Energy Partners, GP LLC.
Good afternoon, Your Honor. Russell Post on behalf of the plaintiffs, appellees, and cross appellants. And with me off the screen is my partner, Chad Flores, who will be arguing the cross appeal.
Pardon my mistake. I refer to you as Mr. Redden, but that is your name, the name of your firm, correct? Beck
Correct,
Redden?
Your Honor.
Okay. Thank you for that clarification, Council. Ms. Jameson, we are ready when you are.
May it please the court. Good afternoon. Again, Marie Jameson on behalf of Southcross Energy Partners. Thank you again for the opportunity to present oral argument in this case, as Justice Chappas said, in these extraordinary times. So I thank the court for allowing us to present argument. Southcross is asking this court to do one of two things. First and foremost, we ask that the court reverse and render. Reverse the jury findings on liability and gross negligence and render a take-nothing judgment against the plaintiffs. Second, in the alternative, at the very least, the judgment should be modified to reflect an accurate calculation of the punitive damages cap. It's Southcross's position that this case should not be sent back to the trial court. There's no factual sufficiency point that's been raised by either party, and there's no basis for sending this case back to the trial court. And let me just briefly say, plaintiff's request to remand this case back to the trial court is its second attempt of 3 attempts to send it back to the trial court, undo the first verdict, and get more money. So plaintiffs had a trial and they received a substantial verdict, $30 million. And plaintiffs were fine with that verdict. They had no complaints about the award. It wasn't until they actually realized that settlement money they received from Firmenite, a co-defendant, those settlement proceeds almost completely offset the $30 million verdict. And it wasn't until then that the plaintiffs tried to undo that first verdict and get more money. And so the first attempt was when plaintiffs convinced the trial judge to bring back the jury and render a second verdict. And to be clear, the jury was not brought back to reconsider liability or reconsider gross negligence. The jury was only brought back to award more money. And that's what they did. Now, this attempt failed after a mandamus and after a new trial order when the trial judge resigned and Judge Watts was appointed to the case. Judge Watts set aside the second verdict and rendered judgment on the first verdict. The second attempt by plaintiffs to undo the first verdict is this jury qualification issue that they've raised in this appeal. I'll circle back to that in a minute. The third attempt was filing a new lawsuit. Plaintiffs have filed a new lawsuit in the same county, Duval County. It involves the same plaintiffs, the same issues, the same parties. The only thing that the plaintiff is hoping will be different is a different damages award. And so circling back to now this second attempt to undo the first verdict, this jury qualification issue, this is not a reason to send this case back to the trial court. And I'll highlight a few things for the court before I get to the rendition points. The qualification issue is waived. It's waived for two reasons. Number one, plaintiff's counsel during jury selection did not inquire about the qualifications and specifically the residency of juror number 6. Now, the cases in the courts that have looked at this waiver issue in this context have all held that the complaining party must show that there was an individual voir dire of that juror based on that qualification ground. And the key case came out of this court. It's the Mercy Hospital case, which was issued by the court in 2012. And we cite to that case in our briefing. This court held in Mercy Hospital that the complaining party must show that they actually asked questions to that juror on the specific ground for disqualification. And that didn't happen in this case. Now, while the trial court during jury selection asked a collective question about residency, plaintiff's counsel did not ask an individual question to juror number 6 about her residency. And by failing to do that, that issue was waived. That's clear from the standards that were articulated in this court's opinion in Mercy Hospital. Secondly, the issue was waived because plaintiffs sought relief based on juror number 6's participation in the second verdict. Now, when the second verdict came down, my colleague on the other side referred to this verdict as, quote unquote, the true verdict. Well, juror number 6 participated in that verdict. And when that verdict was received by the trial court, plaintiff's counsel asked for judgment on that verdict, and she participated in it. And so by being willing to accept her participation in the second verdict, the jury qualification issue has been waived. And to be frank, I don't think that plaintiff's counsel has given this court a good reason why this juror's participation in the first verdict is unacceptable, but her participation in the second verdict is acceptable. The issue is waived. And even if this court doesn't find that the issue is waived, there's no abuse of discretion. Now, in considering the motion for a new trial, Judge Watts acted as a fact finder. And so she received evidence, she reviewed it, she weighed the evidence, and she made credibility determinations. And the evidence on residency is conflicting. There's no doubt about that. The evidence is conflicting. On the one hand, you have juror number 6, Melinda Chapa, testifying in a deposition and live at the new trial hearing that she was a resident of Corpus Christi in Nueces County. Now, this is after the fact. And then you also have her parents who testified to the same thing, that she lived in Corpus Christi. Juror number 6 testified at the new trial. And so Judge Watts was given the opportunity to observe this juror in person and make credibility determinations. And so you have that evidence on the one hand, and then you have a mountain of conflicting evidence disputing that. Trial was in September of 2017. And so looking at the year prior to trial in 2016, you have Ms. Chapa's driver's license, which has a Duval County address. And then juror number 6 also registered to vote in Duval County in 2016 and actually voted in Duval County. And then May of 2016, juror number 6 applied for an absentee ballot, and she voted absentee. And then looking at 2017, the actual year of the trial, her professional license, her cosmetology license listed a Duval County address. And then just 4 months prior to trial, Juror number 6 is Facebook
If I-
post.
If I might interrupt you right there, please. Why don't we focus on the legal sufficiency arguments that you've brought forward with respect to gross negligence? Simply because, you know, that I'd like to focus there. And let's talk about the factual evidence in the record. I believe you said that there were no vital facts that were disputed or undisputed. Can you clarify that for us, please?
Sure, Your Honor. And with respect to gross negligence, and our position is that the gross negligence finding should be set aside because there's no basis to support the liability finding. And so without that predicate liability finding, obviously there's no gross negligence.
Thank you.
And I can circle back.
Let's take a step back then and let's focus on the negligence, the liability finding on negligence, and then we can go from there. And let's hone in on those issues so that we can make sure that we are fully briefed on your arguments.
Understood, Your Honor. So with respect to liability in question 1A, there's no duty owed on the part of Southcross to third-party Firmenite. And under the general no duty rule, Southcross cannot be liable. And then there's no control finding. Plaintiffs actually tried this case without asking the court for control finding. And so there's no duty on the part of Southcross to a third-party independent contractor, and this is not a control case. Without duty, without control, there's no liability, and there's no basis to uphold that finding.
Ms. Jamison, you know, the Texas Supreme Court case, or Supreme Court in 2015, and this has been the law for quite some time, has stated that a landowner owes a business invitee a duty not to injure the invitee through contemporaneous negligent activity. Do you agree with me that the Galbraith employees on the date of the incident were business invitees on Southcross's property?
I do think that there's evidence to support that, but
so we know that there's undisputed evidence that Dennis Henneke, a Southcross employee, or let me back up. We have undisputed evidence that Southcross hired Firmenite to conduct hot tapping operations. And that was to tap into a gas line that has flowing natural gas through it. And there was a lot of testimony about why they hire Firmenite. You know, they're not in that business. It's dangerous. It's you know, so for a lot of reasons, they hired Firmenite. So why does Southcross not owe a duty to Mr. Gonzalez and Mr. Elizondo for the contemporaneous negligent acts of Mr. Henneke when he took over the hot tapping machine and he was not qualified to do it, was not supposed to be doing it? So why does Southcross not owe a duty?
Your Honor, the way that this case was submitted, it wasn't a premises liability or negligent activity case. The way that it was submitted was just duty breach causation. And so it was plaintiff's burden to prove that Southcross had a duty to the employees of an independent contractor. And under the Texas Supreme Court's opinion in Redinger, there has to be some evidence in finding of control, and there's no control finding. And so without that control on the part of Southcross.
So so you're saying that Mr. Henneke did not assert any control at the job site? I mean, he actually took over the operations and was operating the machine. Is that not sufficient control?
He did not take over control over the operation when this hot tap procedure went forward. It was based on and done pursuant to Firmenite's policies. Firmenite's equipment was used. And when the Firmenite tech became fatigued, the Southcross employee offered to help the Firmenite employee. And then at some later point when the Southcross employee became fatigued, Galbraith, the supervisor, and then the two plaintiffs involved in this case, they just jumped in the ditch and decided to help out. But there was no instruction or direction on the part of Southcross, and definitely no control. And I think more importantly, there's no control finding. There's no control finding that would support the theory of liability as submitted by the plaintiffs. And this is the way that they asked the trial court to submit the case.
And what about, did Southcross have a non-delegable duty to to Mr. Gonzalez and Mr. Elizondo there, because it's statutorily prescribed that, there was evidence at trial about 49 CFR 192 that applied to pipelines, and how you've got to make sure that, if you're going to employ an independent contractor, that contractor is qualified. Was there any non-delegable duty there?
There was no non-delegable duty for a few reasons. So the CFR section 192.627, no court has held that actually imposes a non-delegable duty. If you look at the restatement section that they focus on or rely on, which is 424, it requires the statute to provide a specific safeguard or precaution. And so even the mere fact that a statute imposes an obligation does not in and of itself make it not a non-delegable duty. And
well,
so
here it's clear, and it's the jury was able to make a determination or perhaps draw reasonable inferences that a duty that Southcross had was to, or non-delegable duty that Southcross had was to provide a qualified crew to conduct the hot tap procedure. Is that not correct?
As a matter of law, I don't think that's correct, Your Honor. And because again, in order for 424 to be triggered by a statute, the statute itself has to provide a specific precaution. If you look at the CFR section, it just it invokes a general obligation to provide a qualified crew. There's nothing specific about that. The statute doesn't say what licenses, what certificates, what constitutes a qualified crew. And
okay, then what do we turn to determine what constitutes a qualified crew under these specific circumstances?
Well, I think that's the flaw in the statute. The statute doesn't say what a qualified crew means. Again, it doesn't list out any certifications or licenses that makes a crew qualified. And then also, I don't think that the statute or there's any evidence that the statute was actually breached. There's nothing in the statute that says Southcross cannot hire an expert in hot tapping to actually perform it. It just says the hot tap has to be done by a qualified crew. It doesn't say
but doesn't Southcross have any duty to ensure that a qualified crew is in fact conducting such a procedure as a hot tap procedure?
I think that's a huge burden to put on an employer. I think the more prudent thing to do in these, this type of operation, that if an employer is not qualified in a specialized area, to actually contract that work out to a contractor who has the expertise in it, as opposed to trying to do, that specialized work by itself. And it's a huge burden on an employer who is prudent enough to hire a contractor who specialized in a particular area to screen the employees of the independent contractor. That's a huge burden. And I don't think that the statute requires Southcross to do that. So
perhaps under negligence theories, arguably that would not be the case. You mentioned something earlier that the plaintiff's legal theories were not framed to focus so much on Mr. Henneke's action or inaction, acts or omissions when he did take control of the hot tap machine. Let's focus on William Boyer's acts or omissions. What does the record indicate how Mr. Boyer contemplated safer alternatives to a hot tap procedure?
There was 3 witnesses that testified at trial about what Southcross did in coming to the ultimate decision to do the hot tap. And it was a remote decision. It's our position that it's not even the proximate cause of the actual accident, but there's 3 witnesses that testified, 3 Southcross employees who testified that Southcross did indeed look at other alternatives. And this included shutting down the plant and doing a cold cut. And there was pros and cons to not doing the hot tap. And after considering and roundtabling the issue of how to replace this valve, they decided that the more prudent and safer thing to do was the hot tap.
Now, the jury heard the testimony.
Go ahead, Justice Rios.
Okay, the jury heard the testimony and they didn't believe that when they answered question number 9, I believe, right?
That's
And
correct.
I've looked at the testimony, and you mentioned 3 individuals from Southcross. You referred to 3 who testified. And I'm going to read their brief testimony. Mr. Boyer testified, I know there were discussions that took place about where to do the hot tap or how to do the project. He also said, I do know there were extensive conversations. Then Mr. Evans, that was it. That is all he testified to. Evans says, I do remember at least 2 occasions having conversations with Mr. Stroman about alternatives. He also said, had couple different conversations with Mr. Stroman about different alternatives besides doing the project in the format that it took. And he was asked, did you have conversations with Mr. Stroman? Yes. What was the subject of those conversations? Different ways to approach the project. And then the third person, Mr. Stroman, said, we did look at other options. That is the testimony the jury heard. It wasn't about, if we do a cold cut, here are the dangers. Here's why we're not doing it. If we decide to reroute, here are the considerations. This is why hot tapping is the way to go. So what other testimony can you point us to where we've got some facts because that support that they actually gave it careful consideration?
That's, Your Honor, that's the extent of the evidence, but it is evidence that Southcross considered other alternatives. And there's no evidence that the plaintiffs presented that contradicts that evidence. No one testified, there was no.
Ms. Jamison, if I might interject a question here, based on the testimony that Justice Rios provided us with, is that the sole evidence that you are referring to, the testimony, in terms of it was roundtable, there were 3 to 4 people in a room and they had one discussion about whether hot tapping versus shutting down the entire plant?
I apologize.
Go ahead. Is that the sole evidence that you are relying upon?
It's
or
only,
is there?
that's
Let me just
only,
ask one question, and I know that the clock is getting close, but let me ask you this. Aside from the testimony, is there anything in the record that the jury could have contemplated, weighed, to determine that safer alternatives were not contemplated? And if so, what extra steps should the appellees have shown that Southcross should have taken? In other words, should Southcross have put pen to paper? Should they have taken measurements? Should they have had certain certificates in terms of the pressure? Because obviously this hot tap procedure has a lot to do with pressurized, and with qualified crews, et cetera. Aside from conversations, was there anything that was presented before the jury that showed Southcross was indeed contemplating alternatives?
It's only from these 3 witnesses, and it was more than one meeting. I mean, Greg Evans testified that he remembers being in at least 2 meetings. But to answer your question, the evidence that Southcross looked at other alternatives comes solely from these 3 witnesses. Justice Chapa, I think you also asked me whether or not there is any evidence conflicting that Southcross did not consider any alternatives. And no, there's no evidence of that. Appellees provided no evidence that Southcross Southcross did not consider any other evidence. So it's undisputed evidence. I understand, Justice Rios, in your question, if there's anything else that was a little bit more specific about what they actually contemplated and the specific pros and cons. But these 3 witnesses testified that other alternatives were considered. There's no evidence rebutting that. And the fact that there's no documentary evidence that corroborates that is not evidence. And plaintiffs are not entitled to an inference based on the absence of corroborating evidence.
So I have one question. I know you're out of time, but just very quickly. The jury also heard testimony from Mr. Stroman, who was the manager who maintains the pipeline that this hot tap was performed on. And he testified that he has never shut down that pipeline he has never planned it. He's never shut it down. Even when the Woodsboro plant has shut down, they have rerouted the gas. So could the jury have inferred from that there was never any intention to shut down the pipeline?
I don't think that plaintiffs were entitled to an inference based on that because it does not contradict what actually happened on this occasion.
All right, thank you.
Thank you, Ms. Jamison. Mr. Post?
Good afternoon. May it please the court.
Good afternoon, Mr. Post.
Because this case has several moving parts, I want to begin by providing a roadmap of our arguments today on behalf of Renee Elizondo, who was injured in this explosion, and the family of Jesse Gonzalez, who of course was killed. The plaintiffs are aligned in this case, but they seek different relief. The plaintiffs are united in their views that the evidence is sufficient to support the jury's findings and that the juror was disqualified and a new trial would have been warranted. But Mr. Elizondo elected not to raise that new trial complaint in this appeal that he has a right to do, and to elect to affirm the judgment. The Gonzalez family seeks a new trial as set forth in our cross appeal. That's perfectly orthodox for the parties to seek different relief. And so today I'll speak to the Southcross appeal of the main judgment. My partner, Mr. Flores, will speak to the cross appeal. I think it's interesting that the argument began as it did. I'm not sure I've ever seen an appellant want to spend the first half of the appellant's argument arguing against the cross appeal. I think it speaks volumes about the confidence that Southcross has in its appeal of this judgment, because this judgment stands on very solid footing. And I want to begin, Justice Chapo, where you ended with my opposing counsel, inquiring about the conduct of William Boyer and precisely what was entertained in the decision to undertake this hot tap. Because there are multiple liability theories upon which this judgment can be affirmed. But I want to invite the court to look at the most fundamental theory, which is the one that involves Mr. Boyer's conduct, and it leads directly to the gross negligence finding. And that is the decision to undertake a hot tap in the first place. Mr. Boyer admitted he is the ultimate safety officer for Southcross, and he approved that decision. And the evidence in this record is remarkable about the extent of the negligence that afflicted that decision, because the Southcross safety manual itself recognizes that hot tapping, that is tapping hot operations into a flowing gas line, is, and I quote, exceptionally dangerous. You see that in volume 22 of the record at page 240. That's not our expert testifying, that's their own safety manual acknowledging that danger. They recognize that hot tapping is exceptionally dangerous because it entails an inherent risk of explosions and death. And their own witnesses, these three witnesses that counsel alluded to, all had to acknowledge that they understand that risk exists. If you look at volume 13 of this record at pages 86 to 88, and again at page 153, you will find Mr. Boyer acknowledging he knows precisely of that risk. And so the industry has a standard of care for dealing with that risk. And the standard of care is you undertake a careful, disciplined analysis to determine whether there are reasonable alternatives that will avoid the need for a hot tap. And
Mr. Post,
yes,
what evidence did the jury hear to determine what steps should have been taken in order to conduct a proper analysis as to what procedure to undertake with respect to changing out the valve?
The jury heard expert testimony from the plaintiff's expert, and they heard testimony based on the American Petroleum Institute standard, which sets forth the decision tree that is to be undertaken. And while I know the court won't see the exhibit, I'll allude to volume 22 of the record, page 605. That is the decision tree, which the API sets forth. It's a 5-step analytical process. And it calls on decision makers to consider whether there's any safer alternative to a hot tap. And the first step in the analysis, after you determine whether continuity of service is essential, is to ask, is a system shutdown impractical? And if the answer is no, you could feasibly shut down the system or reroute the gas or depressurize the system, the industry standard calls on you to take that course rather than hot tapping. And so
Mr. Post, I'm aware of that decision tree to which you just referred. What evidence did the jury hear that Southcross had to have taken more steps with respect to the decision rather than just roundtabling the decision? In other words, should they have had, did the jury hear, what if anything, should they have gone above and beyond the call of duty, for instance, rather than just simply having conversations? We know that Southcross did have experience in a business working relationship with Firmenite. We know that there was no prior incident to have alerted Southcross. Correct me if I'm misstating what the record shows. We know that that they had conducted another hot tap procedure the day of the incident with no consequence. So what should Southcross have done, if anything, in addition to just simply having conversations?
Your Honor, the question, which is founded on my opposing counsel's argument, is founded on a fundamentally false premise, which is that those conversations, those roundtable discussions even occurred. That was a seriously disputed premise. There is no corroboration that those conversations even occurred. I want to speak precisely to that assumption momentarily and say, even if a brief roundtable discussion occurred, that wouldn't be enough to satisfy the standard. But do not accept the premise, contrary to the jury's verdict, contrary to this evidence, that those roundtables occurred. Because in cross-examination, when every one of those witnesses was pressed for any kind of corroboration, every one of them had to admit there was no documentary record that confirmed it, that when you make a significant decision like a hot tap, it is to be expected that there would be a written analysis, there would be written engineering plans that would be done to consider alternatives, and there was no record of any of that. And I would invite the court, I'm going to give you about 4 important record passages where you can see this examination of the key witnesses. Mr. Boyer's testimony, I'd invite the court to consult pages 112 through 114, where Mr. Boyer has to concede that everything in writing from the very first email on this project indicated that it was going to be done through a hot tap, right? He says, I would say that's probably right. Counsel goes on page 155 and 156, says there is nothing, sir, that you can show this jury where this company went through and actually looked at any alternative other than a hot tap for the Valve 16 project, correct? And he said, not in writing, no, sir. Likewise, I invite the court to look at the testimony of Greg Evans, who was the director of operations for the Gulf Coast region. I will say candidly, Mr. Evans, I think was a somewhat more forthcoming witness than Mr. Boyer. And he was fairly candid in acknowledging that it was unsurprising that every documentary record related to this project suggested that a hot tap was the only alternative that was ever considered. Volume 13 of the record, beginning at pages 231 and going through page 233, recognizes that all of the documents indicate that Southcross went directly to the hot tap scenario and never considered anything else. And then finally, at pages 266 to 268 of volume 13, that discussion comes to a conclusion. And I want to quote to the court what the jury heard on this issue. The final note on this point. Counsel said to Mr. Evans, if we follow the documents, before a lawsuit was ever filed, before 2 men were killed, before 1 man was seriously injured, we see that the only thing Southcross considered was hot tapping and none of the other alternative solutions. True? And Mr. Evans said, from a documentation perspective, that's true. If you follow the paper trail, counsel said that's true. And he said, that's true. The jury had every right to believe that this testimony, this self-serving testimony from interested witnesses from Southcross, claiming that they, quote, roundtabled the idea of an alternative solution was a lie. That's what OSHA found, because this record reflects the OSHA citation that they did not consider alternatives. And so you can find that. Yes, Your Honor.
Mr. Post, so let's assume that they did not consider alternatives. Can you tell us, or can you point us to evidence that indicates Boyer proceeded with conscious indifference to the rights and safety of Mr. Gonzalez and Elizondo?
Yes, Your Honor, I can. And the key here is to recognize the way the Supreme Court understands the conscious indifference inquiry. Because conscious indifference is, as the court recognizes, virtually never shown by direct evidence. You never have a decision maker saying, I just didn't care about the consequences. The way you prove conscious indifference is circumstantial evidence based on the actual knowledge of the decision maker of the risk and the decision to go forward in the face of that risk. And the jury is allowed to infer conscious indifference. That's true in the Lee Lewis versus Harrison case. It's true in Mobile versus Ellender. It was true in the Columbia Medical Center case. And it was true in the 14th Court of Appeals decision in Seminole Pipeline, another gas explosion case where there was evidence that the decision makers knew about the hazards of their gas operations and chose to go forward. We have just that evidence here because Mr. Boyer admitted that he knew about the hazards of hot tapping, admitted he knew it was exceptionally dangerous, admitted he knew that the expectation was to consider every alternative. They didn't
the jury also hear that potentially a cold cut could just have the same, if not greater, inherent risks?
Well, Your Honor, the jury heard a defense case. Certainly, they heard testimony from the defense side of the case. The jury was not required to believe that testimony, and it certainly wasn't required to believe that Mr. Boyer believed that testimony. Remember, Mr. Boyer admitted that hot tapping is exceptionally dangerous. Mr. Boyer admitted that the industry standard that favors shutting down and cold cutting rather than hot tapping to avoiding risks is the appropriate procedure. So the jury was entitled to conclude that was Mr. Boyer's belief. And I think it's important to understand that this kind of argument that the defendants are making, that, well, there was another alternative and perhaps there were risks with the other alternative, the Supreme Court has recognized that is not a legal basis to set aside a conscious indifference finding. This argument that, well, we can prove we exercised, quote, some care, and because we exercise some care, we cannot be consciously indifferent, has been rejected time and again since the Burke royalty decision in 1981. And in
Mr. Post, you mentioned Ellender and Harrison, and Ellender, and I think you indicated just a moment ago that there was, the jury inferred from circumstantial evidence in those cases, but wasn't there really evidence of subjective awareness in those? For example, in Ellender, that's where Mobile was treated employee workers one way and contract workers differently. They took measures, they had policies and procedures to protect employees from benzene exposure, and they didn't have those same measures in place for contract workers. So there was evidence of that.
That's exactly right, Your Honor.
And in Harrison, we had a subcontractor, glass subcontractor, an employee up on the 9th and 10th floors of a hospital that was being built, I believe. And their protective gear was different from the contractor's employees. They had lifelines to protect them if in the event they fell. And there was evidence there that the contractor knew and was actually approved the protective gear that the subcontractor was using. So that was more than just circumstantial evidence. Can you point us to cases that say the jury? Go ahead.
Absolutely, Your Honor. I want to speak to that legally, but also I want to speak factually to the premise you just gave. In both of those cases, the Supreme Court said, as black letter law, conscious indifference, every aspect of gross negligence can be inferred from circumstantial evidence. In neither of those cases was there direct evidence of conscious indifference. What the court said there was direct evidence of subjective awareness, and the jury inferred conscious indifference. In neither Lee Lewis nor in Mobile did the defendant admit they were indifferent. The court said there's evidence of subjective awareness. The jury can infer the indifference from the conduct in the face of that awareness, and that's exactly what we have here. Because Mr. Boyer admitted Just as the actors in Mobile admitted, just as the actors in Lewis admitted, Mr. Boyer admitted that he knew of the dangers of hot tapping. Southcross, as an entity, admitted that it knows of the dangers in its safety manual that acknowledges that hot tapping is exceptionally hazardous. That's just like the mobile policies that were used as evidence of subjective awareness in Mobile versus Ellender. And so the decision to go forward with the hot tap, despite that knowledge, without undertaking the alternative analysis, is exactly the same as Mobile versus Ellender and Lee Lewis versus Harrison with respect to gross negligence.
Mr. Post, let me ask you guys if I might interject a question here. Did the appellees have any burden at trial to show a safer alternative method or procedure that didn't have the same, this is arguably, Ms. Jamison, didn't have the same inherent risks as a hot tap procedure?
Your Honor, I don't think that there's a burden on the plaintiffs in the way that there would be a burden in a product liability suit to show a safer alternative design. But I do think it's important to know that the record did develop evidence that the alternatives of shutting down, of rerouting gas and supplying the customers from other gas lines was established by this record. And there's ample evidence in the record that Southcross could have undertaken those alternatives without undertaking the same degree of risk as a hot tap. It could have done it economically. It could have done it from a safety standpoint. It simply chose not to do it. And the reason the evidence reflects is that Southcross wanted to keep the gas flowing in the pipeline because it was economically advantageous to do so. So the record meets all of those expectations. I do want to reserve at least a bit of time for my colleague to be able to address our cross appeal, which really we think is the principal disputed legal issue before the court. So unless there's further questions on the main judgment, I'll yield to Mr. Flores.
Thank you, Mr. Post.
Thank you, Your Honor.
May it please the court. The Gonzalez plaintiffs seek a new trial because Juror 6 was disqualified. Juror 6 did not reside in Duval County. She resided in Nueces County. She said that in her affidavit. She said that in her deposition. She said that when examined at trial. Her family said that, and so did her employer. Now,
also, if I might interrupt you there, we are well aware of what is in the record before us. Let me ask you this. Your co-counsel opened with stating that every claimant is entitled to seek his or own relief or respective relief. Help me reconcile that the Elizondos and the Gonzalez's are seeking different relief and your arguments potentially could have a conflict.
Your Honor, the relief is different because the claims are different. The core reason for the Gonzalez plaintiffs to seek a new trial is that the damage award they received from this trial did not suffice. It is a rare bird for a defendant to stand up and embrace a judgment of this magnitude. They want this judgment for a reason. They know that this judgment's actual damages award does not suffice to compensate my clients. And so the law has always recognized the ability of different litigants to pursue different claims. And if this court awards the Gonzalez plaintiffs a new trial, that won't trickle down and require a new trial for the Elizondo plaintiffs. They've made their choice and have a right to do so. And while we're on the procedural point, let me put a nail in the coffin of these waiver ideas. You heard a waiver argument that said that the question wasn't posed about juror qualifications, and it was. It was posed by the trial court itself twice, and we received individualized responses from this particular juror in the questionnaires they filled out. We have answered the Mercy Hospital case that you were given. It does not hold what my friend says does. And when we moved for a judgment on the second verdict, we didn't get it. We did not get it, and that means there's no estoppel. Let me draw the court's attention to two critical legal points. These are matter of law legal points, not abuse of discretion points, not clear error points, matter of law legal points that will solidify our argument for a new trial. And the first is as follows. The district court here, when it evaluated the evidence of residents, employed a legally erroneous test. It employed a heightened burden of proof. You'll see this at 21 RR 52 and 53, where the district court says that because this juror once resided in Duval County, The district court was going to assign a legal anchor to that and require that presumption to give it weight and require it be rebutted by some amount of affirmative conduct. What kind of affirmative conduct would overcome this presumption? We don't know, because no court anywhere has ever used that rule. That is not the test. What should have been done is a tabula rasa, clean slate analysis of the relevant moment in time. It says, during the time of trial, did this juror have a present intention to call Duval County home? And she didn't. That matter of law legal error that we've identified has never been answered by Southcross. The other matter of law issue that really needs to be addressed here is Southcross's error. They know that if the court has to evaluate this evidence and pick one county versus the other, they're going to lose. May I have 30 seconds to conclude this point, Your Honor?
Yes, go ahead.
Thank you. They know that if there can be only one residence under the law, they're going to lose because the weight of evidence shows that it's Duval County. And so they propose to you a test that is wrong and that was not used below. Their test says that jurors can have multiple residences. And for them to win, what they say is all they need is some evidence that this juror resided in both places. That legal test is wrong. There can be only one residence. And what they're proposing to you is wrong under the statute. It's wrong under the context of the statute. And it's just wrong as a matter of common sense. Texans only have one home. When you go home, you only go home to one place. But they're giving you a test that wasn't applied below and is wrong. We didn't hear any answer to that during the first part of the argument, and I think we should hear it now.
Can you point us to any authority that says what you just stated, that you can only have one residence?
Yes, Your Honor. So we point to the code itself. If you look in the government code, it's chapter 62. You'll see in our brief that we go chapter and verse, or section, if you will, that every instance of the code is a singular use of the word residence. Other statutes, like the venue statutes, use concepts like domicile, which can be multitudinous, but not here. So those are the authorities that we've given you, and we've seen none to the contrary.
So the courts have never had to deal or faced this particular issue?
Correct, Your Honor. We've seen no contrary holdings, and all the holdings that we do see make the same presumption that we do, which is that there's one and only one residence.
Do you have the burden to, before you sit down, counsel, do you have a burden to show harm?
We do have a burden to show harm, and we did here. So the harm analysis comes from the Palmer decision. The Supreme Court's decision in Palmer says that if you have a 10-2 verdict that's adverse and your disqualified juror is one of the 10, you get harm as a matter of law. That is this case.
So in this case, if I understand correctly, the juror that you challenge actually agreed to the verdict in your client's favor. Is that correct?
That's correct, Your Honor. As to liability, the adverse portion is as to damages. And you'll see in the other side's brief, they tell you the two votes that didn't participate in the verdict would have given a higher damage number. That proves the point. This disqualified juror participated in a verdict that's adverse to us because the number was too low. She was one of the people that brought the number too low. The harm is clear under Palmer. If the court has no further questions, we'll reserve for rebuttal. Thank you.
Thank you, counsel. Ms. Jamison.
Thank you, Your Honor. Unless the panel wants me to start with the liability, I'll just pick up on the jury qualification issue where Mr. Flores left off. I'll start with harm. And the Palmer case that they rely on, it's incredible to me that they're relying on that case because while it's a 10-2 decision, it's a 10-2 take nothing judgment. The plaintiffs took $30 million in this case. It wasn't harmful. And in fact, Judge Watts said on the record that even if she had found that juror number 6 was a resident of Nueces County, that she could not adopt the plaintiff's position of harm. Obviously, the verdict was favorable to the plaintiffs on liability, actual damages, gross negligence, and exemplary damages. The case that they cite to says actually the exact opposite. It's not a take nothing judgment. And the fact that my colleague on the other side has submitted a brief and has asked this court to affirm the verdict on behalf of his client, Mr. Elizondo, I think that shows that it is a favorable verdict. And then with respect to the 10-2, plaintiffs have not cited to anything in the record to show that the jury was actually 10-2 on the damages question. The jury was not polled on the damages question. And so there's nothing that the plaintiffs have cited to actually prove to this court that that was the question, in fact, that they were 10-2 on. They could have been 10-2 on the comparative fault question. They could have been 10-2 on some of the other questions and not the damages questions. And so they haven't presented that in the record to the court. And then on the issue of abuse of discretion, again, Judge Watts was acted as a fact finder, and she applied this court's standard in Contreras. And so she looked at the conflicting evidence, and the evidence again was conflicting. Chapa testified again after the fact that she was a resident of Duval County. But if you look at all the evidence prior to trial, the year before, the year of, and even just weeks prior to trial, she clearly publicly displayed an intent to be a resident of Duval County. And then I think most significantly, she actually showed up when she got her jury summons. Juror number 6 showed up to jury duty, and she was ready to serve on this jury. And then when she filled out her jury card, she had to do so under penalty of perjury, and it asked for her home address, and she wrote in a Duval County home address. And Watts cites to that on the record. And then
Ms. Jamison, would you address opposing counsel's argument that this is not an abuse of discretion standard of review for us, and that because it's statutory, it's a matter of law?
That's not the test, and I think that's contrary to this court's decision in Contreras. It's also contrary to this court's opinion in BZ Tire Shop. And so I'll just go to the Contreras case out of this court. In that case, there was conflicting evidence of residency, and this court said that the proper standard of care is abuse of discretion. And when there's conflicting evidence that's presented to the trial court, there is no abuse of discretion in the way that the evidence was weighed and credibility determinations. And so this new test that my colleague on the other side has articulated is not the law of Texas. It's never been cited or articulated by any court, and it's in direct contradiction to this court's opinion in Contreras. And one other thing I'd like to point to before I move on to our rendition point in gross negligence is that if you look at the new trial hearing, Judge Watts went through the course of conduct, and she looked at when juror number six came back to the Duval County area and all the actions that she took. Judge Watts looked through at her employment records. Some of these were government records where she had to swear under penalty of perjury her home address. Again, it was Duval County. And then the fact that juror number 6 voted in 2016 in an election, Judge Watts said, well, I have to believe that she did not vote illegally. And so she was a Duval County resident in 2016. And then the fact that she showed up to jury duty, she served on the jury, she swore under penalty of perjury on her jury card and the questionnaire that she was a resident. This is the day of. And then even during jury selection, Judge Annalisa Garza told the panel, I don't want anyone on this jury who's not a resident of Duval County. And then she gave the example of Jim Wells. She said, Jim Wells is our neighbor. And if you live in Jim Wells County, I do not want you on this panel. And juror number 6 didn't say anything. It's also compelling, this is the last point I'll make on the evidence, that when the jury was brought back on the day of the verdict, each one of the jurors were questioned about the first verdict. And juror number 6 described what she did when she left the courthouse. And she said she went home, quote unquote, she went home and put her pajamas on, watched traffic, and then she was called to come back to court. Now the jury came, the verdict came in at 6:50 and the jury was called back around 7:30. So that was an hour and a half time period. There's no way that home, the reference to home, was Corpus Christi. And again, this is the day that the verdict was returned. And then we also in our briefing cite to Facebook posts. Again, these are the words of juror number 6 referencing Duval County as her home. And that's a week or two before trial. And so in light of this conflicting evidence, there's just no abuse of discretion on the part of Judge Watts. And this test that has been manufactured by the other side really dispels a longstanding case law in this state that the trial court is to act as the fact finder on these issues. And if there's no other questions on the jury qualification issue, I'll move on to gross negligence. And I'd like to focus on the subjective prong. Justice Rios was right when she was questioning my colleague on the other side about Lee Lewis and then also the Ellender case. This case is not Lee Lewis. As Justice Rios said, in those cases, the contractor was clearly aware that there was a risk of harm and had a conscious disregard when its own employees had protective gear in the Ellender case and then fall protection in the Lee Lewis case, and saw that its own employees were working aside contractors who didn't have those same safety measures. That's not this case. And in fact, when Southcross decided to do the hot tap procedure, they did the prudent thing. They hired experts to do it because they did not have the expertise. Their own employees didn't have the expertise to do a hot tap procedure. They hired a third party who's qualified to do that, to do the job. That is a regard for the safety of others. And I'll remind the court also that on the day of the accident, Firmenite successfully completed a hot tap procedure without any issue.
Ms. Jamison, you seem to suggest that simply because Southcross hired Firmenite to conduct the hot tap procedure, that absolves Southcross from any further inquiry or action to ensure that the hot tap procedure is done effectively, safely, with a qualified crew. Is that your position?
That is our position. There's nothing in the case, the gross negligence cases, that would require that. Again, the prudent thing to do is to hire an expert in that particular field. And
part of your position, you refer and you believe that because you don't think there was a non-delegable duty that Southcross had for the safety of individuals at the job site during the hot tap. Is that correct? Because you say the statute is too general and
that, as well as there's no basis for imputing that liability because it's the actions of Firmenite that caused the accident. It's the tech that committed, that did the procedure, and then also the out-of-date equipment that was used. Those are the actions of a third party. And so just in the gross negligence analysis, there's no basis to impute the liability of a third party for purposes of gross negligence. It has to be
how do we reconcile the fact that Mr. Henneke took control of the machine? And how do we reconcile that? Isn't that in the purview of the jury? The jury can weigh what was presented before them and draw those reasonable inferences where, it's undisputed that Mr. Henneke was a Southcross employee, correct?
That is undisputed, but that act was not, and there was no evidence that act was a proximate cause of the accident. The evidence.
Okay, but it's also undisputed that Mr. Henneke was not a qualified individual to conduct a hot tap procedure.
That's right.
I'm sorry. This is difficult not to speak over one another. So help us reconcile the fact that this truly was potentially something the jury contemplated and weighed.
Well, there, as a matter of law, I mean, setting aside, again, we haven't made a factual sufficiency challenge, but as a matter of law, there was no control on the part of Southcross. There's no control finding. And so, again, the analysis for gross negligence, there's no basis for imputing the acts or omissions of Firmenite. It wasn't our piece of equipment and it wasn't our tech. And then with respect to Mr. Henneke going down to do those few rotations, that was not the cause of the accident. I mean, there was no evidence that in and of itself caused this accident. And looking at the heightened standard for gross negligence, it's clear and convincing evidence, not preponderance of the evidence, but clear and convincing evidence that, again, focusing on the subjective prong, that Southcross had a conscious indifference for the safety of others. And I think that by hiring an expert in this field, there's not a conscious disregard. And the law does not impose a duty on behalf of Southcross to screen Firmenite's employees. The testimony showed that Firmenite had been used in the past. And again, Firmenite performed a hot tap on the very day of without—
Ms. Jamison, assume with me that the hot tap machine did explode when Mr. Henneke was operating it. Do you then agree that Southcross would be liable in gross negligence?
Not based on the way that this case was charged to the jury. The way that this case was charged to the jury was the act or omission of Boyer. And plaintiffs have kind of boxed themselves into this issue. On appeal, they really focused on the fact that there was a decision to do the hot tap. And that's how it was charged to the jury in the gross negligence question. It identified Boyer as the vice principal, not-
But let me stop you there. The jury was further instructed that there could be that Southcross could act as through other vice principals, not just Boyer. So let me ask you this. Can you tell me whether Mr. Evans, Mr. Stroman, or Mr. Henneke were vice principals of Southcross as the jury was instructed?
There's no evidence that Henneke was a vice principal. There was no evidence that he had the power to hire, fire, or control individuals. And again, his name was not the one that was in the charge, and that was never argued by plaintiffs. So there's no evidence of that. And plaintiffs never argued that Henneke was a vice principal. They focused on Boyer as being the vice principal whose decision.
But even though plaintiffs may not have argued, the jury had the charge and took it back to the jury room to deliberate and had the instructions, and they are bound to follow instructions. And in the gross negligence question, it says you are further instructed that Southcross may be grossly negligent because of an act by William Boyer if, but only if, and then it goes through A, B, C, or D, and D is Southcross or a vice principal of Southcross ratified or approved the act. And then it goes on to define vice principal. So it seems to me that the charge was broader than just Mr. Boyer's acts.
And the plaintiff did not submit any evidence. There's no evidence that Henneke was a vice principal. So there would be no evidence supporting an implied finding that Henneke was a vice principal to support gross negligence in question 9. And I see that my time is up. If I could just make one other point on the gross negligence issue.
Before you do so, Ms. Jamison, along those same lines where Justice Rios left off, so let's assume that we agree with you that there's no evidence that Mr. Henneke was a vice principal. D, and I'm referring to the court's charge, D does refer to Southcross. And so isn't there some sort of vicarious liability with respect to Mr. Henneke's actions on the job site itself?
Well, Your Honor, if you give me just 1 second, I'm going to pull up the chart so I can look at that subsection. But there wasn't any evidence that Henneke was a vice principal. And just based on the standards that have been articulated by the Texas Supreme Court, there has to be evidence of a vice principal in order to impute gross negligence onto a company, because obviously a company can only act through its agents. And there's no evidence that Henneke was a vice principal or had the ability to hire, fire, or discipline employees. And so again, as charged, the focus was Boyer, and the only evidence of a vice principal was Boyer. And to answer Justice Rios's question, there might be some evidence that possibly Stroman was a vice principal, but obviously he wasn't there on the job site. And so I don't think just the actions of Henneke can be imputed onto the company for purposes of gross. Now, if we're talking about vicarious liability on just an ordinary negligence, that's another question. But in order to impute liability to a company by an individual, there has to be a higher level of authority by that particular agent. And there was just no evidence of that with respect to Henneke. And if I may just add one other point on gross negligence, the position that the plaintiffs have taken that the decision alone to hot tap as gross negligence is not supported by any case. Hot tapping is done all the time and it's regulated. And I think the fact that it's allowed and it's permitted in a controlled setting rebuts this notion that hot tapping in and of itself is gross negligence. Again, no case has said that. And I think that that's contrary to just the fact that there's regulatory agencies that permit hot tapping to be done, and obviously it can be done safely. So the decision in and of itself to hot tap cannot be gross negligence.
Well, let me just follow up with that. You're saying that no case has held that. It's sort of like saying, I never met a stranger. Well, you're strangers till you meet, right? You're friends. Just because a court has not said it's an inherently dangerous activity. And I guess my question is it something that's a question of law, or, a case of first impression? A court can hold that. So,
well, two responses to that, Justice Rios. One is that there's other cases that have looked at similar activity, such as blasting, welding, construction work in oil and gas refineries, very similar to hot tapping work. And those, in those cases, the courts have held that it was not inherently dangerous and not gross negligence, kind of as a matter of law. I do think that the court can determine whether or not hot tapping is, gross negligence in and of itself. And we would submit to the court that it's not, because again, no case has, and I understand the stranger analysis, but if you look at the cases that have looked at similar type of work, they have held that it's not. And the fact that it is allowed, it's permitted in a controlled setting, that it can't be in and of itself, just the decision to do it cannot be gross negligence in and of itself. There has to be more.
Ms. Jamison, I have one last question. In your brief, you state that Southcross came to determine the shutdown alternative was riskier. How so and why?
I'm going to take you through the actual, give me just 1 second, Your Honor. When Southcross actually spoke to other experts that had shut down the plant, some of the things that they had looked at was how they would actually supply gas to their other employees.
Ms. Jamison, are you referring to conversations with experts with respect to this particular hot tap procedure and job, or are you talking about past experiences with other hot tap procedures?
Well, other experiences, but these were things that Boyer had testified to that they had, that potentially was a reason why not to shut down the plant. And so there were, again, pros and cons both ways, and some of the cons to shutting down the plant included how to actually provide gas to their customers. And then also this particular plant provided gas to other gas companies. And so those gas companies potentially would have to figure out how to provide to their customers. And then there were some safety issues with shutting down the plant, the constricting of the actual the lines, and then also the ability to fully clean out the lines to shut the plant down and to do a cold cut. And so there were some risks associated with actually shutting down the plant and doing a cold cut.
Wasn't the evidence disputed about that? I think Mr. Evans happened to have a different opinion about the dangers of doing a cold cut. So if there was disputed evidence, it was well within the jury's province to believe one witness and not another. Is that right?
Well, the experts testified as to whether or not those were significant or risk that you really should consider in whether or not to do a hot tap. So yes, the jury was within their purview to decide whether or not to believe that was a legitimate reason why. But I think the point is that it was considered. The allegation by plaintiffs is that there's no evidence that alternatives were considered. They were indeed considered. Now, whether or not those were valid reasons, I don't know that that's a basis for gross negligence, because again, if you look at the subjective prong, it's a conscious disregard for the safety of others. And the fact that other alternatives were considered, setting aside whether or not that decision was right or not. And courts have written about whether or not the decision to go a certain route in hindsight if that's gross negligence, and that's not what you look at. When you look at it at the time, they considered other alternatives. Whether or not that was a safer approach or not in hindsight is not relevant to the court's gross negligence inquiry.
Thank you, Ms. Jamison. Unless my colleagues have a question for Ms. Jamison, you're out of time. Justice
I have
Rios.
nothing further. I have nothing further. Thank you.
Thank you, Ms. Jamison.
Thank you.
Ms. Jamison, can you please mute yourself? Thank you.
I'd like to divide the rebuttal into two pieces. First, talk about the error of the disqualification and then say something about the harm. As to the error, I have three things to say. Number one is that we appreciate that the court has seen the briefs and how much detail we've put into the evidentiary question of what the evidence shows. And we will submit that if the court tries to write an opinion that affirms this judgment and says this finding can be upheld, despite all of this evidence, there's going to need to be a section that says, in order to warrant reversal, we would have had to shown X. And that opinion won't write, because as you see in the reply brief, we directly asked every question we could have asked of this juror and got the answers that support the finding we submit. So that opinion isn't going to write if you get down to the evidentiary fight. But as I emphasized originally, we don't need to get there. There are matter law points that have not been answered. The standard of review is de novo because the question is a legal question. What is the evidentiary bar against which this record has to be measured? It's just like a jury charge. If the charge misdefines the question for the jury and makes the bar too low or too high, that is matter of law error. It is not an abuse of discretion error. That is precisely what happened with this fact finder, is that the trial court.
Excuse me, what are you relying on? What authority are you relying on suggesting that that our standard of review with respect to this issue is de novo?
We cite you the Supreme Court's prudential decision in the reply brief, Your Honor, and I think that a litany more say that whenever a court decides what the threshold of evidence is needed, what it has to prove, that itself is a question of law. And the district court here made that error. The second thing I have to say is that we briefed this issue in the main brief at pages 43 through 46, and we briefed it in the reply brief at page 4 through 6. And Southcross has literally zero answer. There is not a single word in the briefs that answers this argument. It is case closed.
Mr. Flores, can you cite us to the record where it shows that this juror, juror number 6, actually found, harmed, is what I'm trying to say. You said that she went against you on the damages. She's the one who kept the damages lower than what others wanted to award. Where in the record can we find that?
That's volume 3 of the clerk's record, page 3586. That's the verdict form itself. I know it well because I drafted it. The verdict form says these 10 or 11 jurors agreed to the following answers, and the specific 10 jurors each signed. Juror 6 is one of the 10. We know because the instruction says these 10 or 11 that these were the only jurors that agreed. So those were the 10 that agreed to liability. She was one of the 10. There's a separate instruction about unanimity for other questions on punitive damages, but the harm for us was that she participated in the actual damages finding, and that's at 3586, volume 3 of the clerk's record.
But now, it isn't any, so you're referring to what is on that page? It's defining the jury charge?
Yes, where it has a list of which jurors voted for the answers. So that's
how can we look at that and determine that she kept the damages lower?
Oh, you don't have to, because the Supreme Court's Palmer decision says that it's error as a matter of law. This is the flip side of the Golden Eagle rule. It's precisely why we don't go and depose every juror and ask them what role they played. Defendants invoke this all the time. Now you have a plaintiff invoking it. It's good for them and it's good for us. Courts are not in that business, and Palmer stands for that exact proposition. She's among the jurors that rendered the verdict, and that creates the harm. The last thing I want to say on this point is about the practical notion that this isn't an adverse verdict. My friend on the other side says that we aren't harmed because we got some damages award. That position is legally absurd. According to them, if this jury had awarded us $1 of damages, that would not be a harmful verdict. We could never complain about it. We couldn't cross appeal because we would have prevailed. Of course, that's not the law. You know that in your gut, and Palmer proves you that it's not the law here. This was absolutely a harmful verdict. The plaintiff is in charge of their case. They are in charge of their demand, and this verdict did not satisfy these plaintiffs. We are not asking for 2 bites at the apple. We're not asking for 3. The children of the deceased, Mr. Gonzalez here, want 1 clean shot to make Southcross pay for killing their dad. And this trial didn't even have a set of qualified jurors to render that verdict. No wonder it didn't suffice. Unless the court has further questions, will you?
Justice Rios, Justice Rodriguez, do you have any questions?
I don't have any more questions. Thank you.
Thank you, Mr. Flores.
Justice Chapa?
Yes, ma'am.
Hey, Jameson. I know that the court has allocated the time and that time is up, but I wasn't able to get to the cap calculation issue. If I could just ask for 2 minutes to briefly argue that to the court.
Well, I'd like Mr. Post, do you want to weigh in on additional time?
Your Honor, I'm an officer of the court. I'll serve at the pleasure of the court. I would simply ask if the court wishes to hear that argument, we obviously are entitled to respond, but I leave it to the court's judgment.
Okay. Justice Rios, Justice Rodriguez, we can go off, or
Is there anything new? I mean, obviously we have your briefs and we've looked at that closely. Is there anything new that you would add? Otherwise, I would say we could probably just look at that. How much time would you need?
Just 2 minutes, Your Honor.
Okay.
I'll be brief.
I think we're okay with 2 minutes, and if Mr. Post would like to respond, you can have 3 minutes. How's that?
I suspect I could do it in 2, Your Honor.
Okay.
Just briefly, we are asking that the court at the very least modify the judgment. I just want to focus briefly on—
Just 1 second, please. Mr. Cruz, can you? Thank you. Okay, we're ready.
Thank you. May it please the court. Just want to focus on 2 questions in the charge, questions 9 and 10. The key issue here is whether or not the recovery on behalf of the estate for exemplary damages, if that can be inflated by using the economic damages of the surviving children. And it's our position that the surviving children are not gross negligence plaintiffs, because 1, if you look at question 9, the jury was not asked whether or not the surviving children were harmed. There's no finding of harm to the surviving children on the basis of gross negligence. And the same thing in question 10, the surviving children were not awarded damages. And so because the surviving children were not harmed as a result of gross negligence, and because the surviving children were not awarded damages. And I'll also note for the court, there's not an apportionment question in this jury charge. Had the plaintiffs wanted the surviving children to receive punitive damages, they could have asked for an apportionment question. And as Mr. Flores said, they drafted this jury charge. This is their jury charge. And so in the absence of a finding that the children were harmed as a result of gross negligence, and in the absence that of any damages being awarded to the surviving children, the estate's recovery should not be inflated by the economic damages awarded to the surviving children. And the seminal case that the plaintiffs rely on, that's not the issue that was considered. The issue that was considered in that case is whether or not the cap could be applied globally. So essentially, the plaintiff will recover just once, or whether or not the cap can be applied individually. And in that case, the court said it's to be applied against the multiple defendants. That's not the issue in this case. The issue is whether or not the economic damages of a plaintiff that's not a gross negligence plaintiff, if that can be used to inflate the exemplary damages of a gross negligence plaintiff. And we would ask that the court recalculate the damages cap to reflect only the economic damages of the estate. Thank you.
Thank you, Ms. Jameson. Mr. Post?
Thank you, Your Honor. Southcross's argument in this respect is mistaken for 3 reasons.
Mr. Post, just 1 second, please. Mr. Cruz, can you please set the timer for 3 minutes? Thank you. Okay, Mr. Post, thank you.
Thank you, Your Honor. The Southcross argument on this point is mistaken for 3 reasons. First, it's contrary to the plain language of the statute. Second, it's contrary to precedent. And third, it's contrary to the public policy underlying these punitive damage awards. First, with respect to the plain language of the statute. By its express terms, the statute provides that punitive damages are capped at, and I quote, 2 times the amount of actual economic damages. It does not refer to economic damages to a claimant. It refers to 2 times the amount of economic damages. And in fact, in section 41.008B, the statute refers to exemplary damages awarded against a defendant. So the focus by the legislature was not on the award to the claimant. It is focusing the limit of a recovery against a defendant, and it's 2 times the amount of economic damages without reference to the particular claimant. Now, the legislature easily could have provided in that language that the cap is limited to 2 times the amount of economic damages awarded to a particular claimant. It did not do so. As this court knows, the courts are to presume that the legislature includes and omits language for a reason. And here, the legislature included all economic damages within the cap. That's the first point with respect to the plain language of the statute. The second point is precedent, because as counsel references, the Seminole Pipeline Court did look at the application of this cap. And what the Seminole Pipeline Court said is that we have to treat the language of the exemplary damages cap literally, even if the result seems counterintuitive to us. And in that case, the court concluded the cap has to be applied on a per defendant basis, precisely as we are arguing here is the legal proposition. Now, what is the significance of Seminole Pipeline? The great significance is that that case was decided before the House Bill for revisions to Chapter 41. The most significant revision to our tort reform statute of the last generation, the legislature carefully looked at Chapter 41, had an opportunity to make adjustments to the way this cap applies if it disagreed with Seminole Pipeline, and it did not change this language. And the Supreme Court says, and we've cited the Grapevine excavation case as one illustration, that when a legislature acquiesces in the judicial interpretation in that way, it codifies the interpretation. The third reason that the Southcross position is mistaken is it's actually contrary to the public policy the legislature was trying to accomplish, because the purpose of exemplary damages is to punish, not to compensate. So it's logical that the legislature was focused on the economic damages caused by the defendant in determining the cap. It has nothing to do with the recovery of a particular claimant. Unless the court has further questions, I appreciate the court's time.
Justice Rios, Justice Rodriguez. Thank you.
I have
Mr.
nothing further. Thank you.
Thank you, Mr. Flores. Thank you, Mr. Post and Ms. Jamison. Your case has been submitted and an opinion is forthcoming, and we wish you well, and please take care.
Thank you.
Thank you.